right. Good evening, everyone, and thank you for joining this webinar. This webinar, our goal today is to empower everybody on this call who have filed or are considering file a complaint with the EEOC. Our goal tonight is to equip you all with the knowledge and resources that you'll need in order to navigate this very complex process confidently. We'll dive into the rights you hold as the complainant. Understanding your rights is crucial for taking these steps in advocating for yourself. We'll outline the key steps involved in the EEOC complaint process so you know what to expect at each stage. What I'd like to do now is allow for our guest to introduce herself before we get started.
Yeah, so hello everyone. Thank you for joining this webinar. I am a licensed attorney. I'm licensed in Texas and Ohio. I also, because the EEOC process is federal, so I help different individuals across the country. And so I am very passionate about this work because sometime in my career, I have had to use this process for myself, to advocate for myself. So that is where the passion comes from, and just helping everyone out in their careers to use this as some resources. So I look forward to digging very deep into the EEOC process with you all, and hopefully that you'll get some resources to help you along the way.
Thank you for that. So, Monique, I guess we can just start at the very top. And can you talk us, or rather walk us through the step-by-step process for filing a complaint with the EEOC? And what should complainants expect at each stage?
Yeah, so I like to think of that there is 5 phases of the EEOC process. That's the inquiry phase, the mediation phase, the investigation slash determination phase, conciliation, and litigation. But due to time constraints of this webinar, we're going to focus on the inquiry process, the mediation process, and the investigation process. First, I just want to point out, as I speak today, I'm going to use some terms interchangeably. So I may say you, I may say the charging party, or I may say the employee. Those are interchangeable. I may say the responding party. I may say the employer. Those are interchangeable, okay? So I'll say you a lot because, you will have to advocate for yourself one day. So the EEOC 1 handles complaints related to discrimination and retaliation based on protected category status. That's race, color, religion, sex, national origin, disability, age, pregnancy, or genetic information. So first, the inquiry process. The EEOC process begins with an inquiry. It's filed online through the EEOC website, and once the inquiry is submitted, you have to schedule an appointment to review that inquiry. However, due to high volumes, and when I'm saying high, the EEOC gets about 187,000 inquiries, that's just inquiries, a year. And so you have to, it may take several months just to get an appointment. The EEOC may reach out to you sooner if there's a cancellation or if the statutory deadline, your statutory deadline, is approaching. The filing deadline depends on the state that you live or work in. It can range from anywhere from 180 days in some states to 300 days, okay? And so once your appointment is scheduled, an EEOC representative will ask you in your appointment to review your claim and determine if you have a sufficient cause to file a formal charge. If your claim is deemed viable, then the EEOC will then draft that charge, and they'll send that charge to the employer within 10 to 14 business days. After the charge is officially filed, then both parties will most likely get an invitation to voluntarily mediate. It's offered to both parties. And in some cases, if the charge is particularly egregious, you may not get an opportunity to mediate because they may want to bypass the mediation and directly investigate to prevent future harm or further harm. But if both parties agree to mediate, the case will then be referred to the mediation department, and if both parties don't agree, then you go to the investigation phase. Now, one thing I just do want to point out in this inquiry process is that If you are facing a very tight deadline and you may be afoul of that 180 to 300 days, it might be advantageous for you to reach out to an attorney, because an attorney who is it's frequent with the EEOC process, they will understand how to use an attorney portal, and an attorney can file that charge for you, and they can get that charge. They bypass the appointment and the inquiry system, and they can get that charge filed for you within a week to 2 weeks. So it's really important that you be abreast of that timeline that you're facing. And then the next phase is that investigation phase, right? In this phase, your charge is going to be assigned to an EEO investigator. The EEOC, remember, handles about 73,000 charges a year. So investigators they're going to have multiple cases at once. So the investigator will then require a position statement from the employer. That position statement is going to outline the employer's defenses and why that employer believes that there should be a dismissal. And so in respond, you as the charging party get to submit a rebuttal. You will hear me say throughout this whole webinar that the rebuttal is super important. A proper rebuttal to a position statement is so vitally important. It's a crucial report because it helps guide the investigator how to proceed with investigation. This is your chance to tell them what rocks to go look under to gather evidence, okay? And the rebuttal should address any missing evidence, any misleading evidence, and provide additional evidence, right? That might be witness statements, emails, records. And investigations take time. This is where you're going to spend most of the time because they have such high caseloads. It just takes a lot of time to get through this to do a proper investigation. And so remember that you don't need an attorney to go through the EEOC process. So if you can't afford an attorney, maybe you can reach out to someone who is experienced with the EEOC and they've written rebuttals, but it's really important that this rebuttal is properly vetted and has the appropriate information. So those are the two and most important phases. And I know we're going to talk more about those phases, Jacqueline.
Yeah, absolutely. And I guess just so a couple of follow-up questions. So obviously, CageBird, we get a number of clients on a weekly basis that reach out in various stages of their employment, but nonetheless are curious about the EEOC process and claim I guess possibilities, right?
Yeah.
So one of the things I want to just get some clarification on is when they're going through the mediation phase, both parties have to agree to mediation, correct? It can't just be
Absolutely.
okay,
Yeah,
perfect.
yep. If one says, and most of the time, right, the employer is going to be the one that says, no, I don't want to do it. And sometimes
Yep.
they're doing it just to buy time. Then it will go to the investigation department. Now, I can tell you that sometimes it will go to the investigation department, and then the other party might change their mind and say, oh, well, yes, I do. It can go back to the mediation
Okay.
department. So that is a chance that happens.
That's good to know. And then another question is around the filing deadline. So you had mentioned that, they have about 180 days in most states, sometimes upwards of 300 or 320. Is that what I heard? Um,
300 days.
300. Okay. So is that from the time of the incident or could it be post employment? When does that clock, so to speak, start to count those days?
Right. That is going to be from the time the actual incident occurred. Now, sometimes it could be extended if there is continuous behavior, right? This behavior continues to happen. Say, for instance, maybe you had an age claim in 2019, right?
Mhm.
And then in 2020, you applied again and you didn't get it because maybe your age, and then you stayed there, and then 2023, it happened again, right? So that's continuous. And therefore, you possibly could go back to the 2018 claim and say that this has been continuous behavior, and then therefore they should go back to 2018. And so that's how that statutory limitations could come back.
That's really helpful to understand. So we have a question actually in the chat that I think is really, really important that we touch on.
Sure,
Are you
sure.
allowed to still pursue EEOC after taking severance?
Absolutely. Yes, absolutely. Now, let me tell you about that. If you have settled, okay, and you've taken monetary compensation, you
Mhm.
still can go to the EEOC. You can go to any regulatory agency to report wrongdoing. Now, if you work your way through the process, the thing is, you may not get monetary compensation. You will then maybe say, well, you know what? I know that they were wrong and the EEOC believes they were wrong too. Can we say that they need to train more or they have a plan of action to correct this behavior? No one can ever, there is no agreement that you can sign in the US to say, I cannot report bad activity to the departments in which we're supposed to be reporting them to.
Thank you. Thank you for sharing that.
Sure.
And then another question we have on this part of the webinar in particular is it advantageous to go to mediation or investigation?
Say mediation, and I'm a little biased because I have been on both sides of the spectrum, right? So I have been on the employer side, and I also now represent clients on the other side. So I'm going to tell you what the employer is thinking. The employer is thinking that, oh, you know what, I'm going to go to mediation and I'm going to maybe do a fishing expedition, right?
Mhm.
I'm coming with some compensation, but I need to get some more information just in case we go to the investigation side of the house and I
Yeah.
have to do a position statement, or it may go to litigation. So yes. And then on the other side, you can do the same thing as the employee, right? You want to know what they're going to put in that position statement. How bad is it? What are they going to doctor up these? Maybe they're going to tell some fibs or something like that. So you want to be ready too for your rebuttal as well.
Mhm.
So I think it's good on both sides, but most of the time when they come to mediation, they're coming in good faith. They know that they have to bring some type of compensation to
Mhm.
resolve it so that the charge will be dropped. So and the EEOC prides themselves in trying to get them resolved. So I will say that mediator is really going to be a neutral third party because that's kind of how they get their kudos that,
Right.
we've settled so many claims, right?
Okay. That makes a lot of sense. And I we have some more questions coming through the chat, but I actually think that some of these are going to be addressed as we engage in this conversation a little deeper. So
Okay.
when we talk about common challenges as part of this process, what are some of the most common challenges the complainants face during the EEOC process, and how can they best overcome them?
Yeah, so I think it's crucial to understand the statutes and regulations that the EEOC enforces. And I say that because I don't want to talk negatively about the EEOC staff, but let's just say that you're not going to get Chick-fil-A customer service. It's more like Burger King service, okay? So you have to be fully equipped to advocate for yourself, okay? So you got to know the rules and regulations. For example, while the EEOC takes claims regarding pregnancy discrimination, they don't enforce FMLA cases. You have to file a claim with Department of Labor for that relief. And so you don't want to, miss your statute of limitations for something that the EEOC can't enforce,
Yes.
right?
Yeah.
And then additionally, not all investigators or mediators are highly experienced in their roles. So you need to help guide them through the process. And this is especially important going through the intake process because
Mhm.
I have seen viable claims get dismissed and they don't even want to make a charge on your behalf because they're saying, well, no, we don't do that, or this is, you don't have a case. Now, if you know the statute or the regulation and how to prove that you do, because I have had to be on those calls and I've had to pop up and say, wait a minute, this is what the rule says. And then they will then go and file that charge for you. So you have to know how to advocate for yourself. The second one, I think, is gathering necessary information or evidence before filing the claim. Because sometimes we don't have all of the information, or the claim's not ripe enough, or it might lack a critical element. And so I do believe that an attorney could be helpful in making sure that you have all the evidence. So for example, over 60% of the EEOC claims in 2023 was unlawful retaliation. But remember that retaliation is based on a protected category status. So if you complain to HR that your manager is being unfair, and then the manager retaliates, this wouldn't fall under the EEOC jurisdiction unless the complaint or retaliation was regarding discrimination based on a protected category like religion. So just making sure of that. And then I think you have to report the issues. You have to report to either your HR, your ER, your supervisor, because I have seen so many times employers will say, they'll use the defense, well, they didn't tell me, they didn't make a complaint, and, the EEOC will take that as a defense. And so accurate documentation is key to proving your case. So I also advise clients to minimize verbal communication, to document these interactions into recap emails. So for instance, I had a client that was terminated for speaking Spanish because, I think the office, I don't know, she was closing deals for them in Spanish with their Spanish customers. But one day they just decided, we're going to terminate you for speaking Spanish, and literally told her that. So I knew that this arrogant CEO was going to fall for this trap. So I said, you know what, I'm going to draft you an email and I want you to send it. I'm not going to send it, but I want you to send it. And voila, he sure did respond in writing. Yes, I terminated you for speaking Spanish and, a whole bunch of other stuff. And so that was really information that we were able to use in the EEOC process. And then once again, I'm going to say this again, prepare a thorough and accurate rebuttal. Keep in mind that the position statements will likely portray you or the charging party as a poor performer, a troublemaker, and you might have to read it on a Friday because it may take a weekend to say, wait a minute, because you're going to feel some type of way. And it's really not that. They are just trying to attack you because you are standing up for yourself. And so don't let that discourage you. Just take a mental break and then get back to that rebuttal to get everything recapped in there. And then the last thing is just patience. It's going to take a minute to get through the process. It can take anywhere from 6 months to 2 years. So just being patient is going to be vital.
So you actually mentioned something that I think a lot of the consultants here at Cage Bird restate to clients every single day, which is document, document, document. If you have a conversation with somebody and it is a verbal conversation, reiterate that conversation over email as
Absolutely.
a follow-up to our discussion, XYZ.
Absolutely.
Because the position that we've always held is it doesn't matter if they respond or not. You've documented it. You've given them the opportunity to restate claims, rephrase, whatever.
Or provide some clarity, right?
Exactly.
If it didn't happen in that email.
Yeah. Yep.
Yeah.
So I really appreciate you reaffirming that. The other thing that's really interesting, and I know personally this is something that I say to clients often, but a lot of clients are hesitant to do this because they've just lost faith in their organization, in their HR department, which is give the organization the opportunity to rectify the wrong, So I do advise a lot of times for clients to go through the investigative process, prefacing, the fact that the outcome will likely not be what you're looking for.
Absolutely.
But the is that you've done this, you've given them the opportunity to essentially hang themselves, right? Like
absolutely.
This is what we're looking for in order for you to be able to move forward with other processes such as an EEOC complaint.
Yeah, and they're going to want to see just as much as a court's going to want to see that you had exhausted your remedies, okay? You have went from everywhere that you can complain, you've made the complaint, and you've gotten no resolution, okay? And also, the answer, the process, I should say, is just as important as the answer. Because if that ER or HR department, right, I'm going to want to know their process. I'm going to want to know, okay, what did you do with the complaint? How long did you take the complaint? Who did you review?
Mhm.
And if there's a botch investigation, that's an issue as well.
Mhm.
So it's really important that you go through the process.
Awesome, awesome. I really appreciate that. Another question that we've received so far is, can a company refuse to rehire you if you're bringing a claim against a separate department within the same organization?
They can. I do see that in a lot of settlements. It depends, though, what state you're in.
Mhm.
There are some states that you cannot do that after you filed discrimination and certain complaints, but there are a lot of states still that you can say they put a no rehire clause in there. A lot of employers feel that it's a high likelihood of retaliation after they bring you back. However, I will say this with the EEOC, though. The EEOC is not a big fan of those clauses, right?
Mhm.
So they're not going to push them per se. It might be something on the side that they'll put in their settlement. But for the most part, the EEOC, they're going to fight for you. If you're still there, they're going to fight for you to keep your job and kind of get some compensation and for you to stay. Because I just had that in a conciliation just recently, and they really were for that individual to stay with her employer and not be terminated, and the no rehire clause.
Excellent. You did just answer the next question, which was, could you or should you stay employed with the company while going through the EEOC process?
I do think with the while you're going through the process, yes, I think you could stay. I
Mhm.
think you should stay. Because I say this because a lot of employers, they do some crazy things, right? And so it just gives you more evidence. They really don't know how to handle, and you
Yeah.
have to collect more evidence. And then also it could be a bargain tool, right?
Mhm.
So I tell my clients, okay, look, it's going to be real hard if you want to stay here, okay? Especially if it's not a huge organization where you can go somewhere else.
Mhm.
It's going to be real hard. So you might need to look somewhere else and then know that this settlement is coming. But maybe that's a bargain. We can say, listen, in exchange for you giving me compensation, I will resign.
Mhm.
So I think that's a good tool to use. Um, but I think thinking about staying when it's not like it's a smaller organization like 5,000 people, sometimes that could be a little tough. And I also believe if it is truly you are there with your mental health, or your health is giving you signs that this is not, you have to put that first and just trust that everything is going to be okay, even if you do decide to resign.
Mhm. Thank you. Thank you for stating that, because it is, everybody should know that no amount of money is worth
No,
your mental health, your wellness,
absolutely not.
your health.
Yeah.
So there are positions in which you may be able to stay and quote unquote tough it out. And you may get to a point where enough is enough. And
Yeah,
hopefully at that point, you've gathered enough in order to
absolutely.
substantiate your claim.
Absolutely. Yes.
So we've talked a lot about mediation, right? Can you explain more on the EEOC mediation process? When is it most effective, and what should complainants keep in mind if they choose mediation over investigation?
Yeah, so if you get to this phase, just remember that they're coming in good faith and they're willing to provide some compensation in exchange for you to drop the charge. So what's key here is thorough preparation. You're going to have a successful mediation if you're thoroughly prepped. So you should clearly understand the laws and regulation you believe that is the employer is violating. So such as Title VII, Civil Rights Act, the Civil Rights Act, or the ADA, American Disability Act. You need to know that. You need to understand that. And I'm not saying that you have to be a scholar in it, but at least understand, the most of the regulation. And you should also gather all the information of your claim and create a detailed timeline, a very comprehensive timeline, because it's going to help you kind of keep your thoughts and keep you focused in the mediation. It's also important to note that most likely the employer is going to be represented by legal counsel. So if
Absolutely.
you can get an attorney, that's great. However, just be cautious during mediation because some employers, like I said, will use it as a fishing expedition to gather information for future litigation. So attorney kind of can spot that out and be careful in disclosing too much information. And you'll know if they're on a fishing expedition if they're like, we'll give you $200. And then the mediator comes back, okay, they've moved up 250. Okay, the most they're going is $1,500. They weren't there in good faith, right? So if you're representing yourself, create a detailed timeline, gather all the supporting information, and then remember, you're going to, in the beginning of the mediation, you're going to be given time to provide an open statement. Draft a two to three paragraph summary. Don't get too detailed. You don't have to memorize it. You could literally just verbatimly say it off of your, whatever you create. And then you will discuss from there. You'll be in a joint caucus, and then they'll separate you, and you'll be in private caucuses. And then the mediator will go back and forth between the private rooms, and you'll get a chance to discuss with the mediator the facts. The mediator is going to need some facts because all the mediator gets is the charge document. That's one page. So they're going to need a little background information to understand both. They are neutral. Remember that. They are neutral. And once you've kind of created a rapport with them, you'll talk about facts. Now, you do not want to talk about facts the entire mediation because you're going to agree to disagree. That's not what we're here for. At some point, I want to get to the money, okay? So maybe the first two conversations with the mediator, you're going to go over facts, and then you want to start talking about, okay, we'll move here and there. Also, like I said, be careful in giving all of the information. You don't want to do that. Maybe sometimes you might want to say, look, mediator, they're not telling the truth here, and I have evidence to the contrary. I will give you the information. I'll send you the email, and I'm asking that you keep this confidential, but just so you know. So then that helps the mediator then go to the other side and say, you know what? You're not being, too. And let me tell you, if you go to the investigation side of the house employer, you might have a hurdle to get over because there's some evidence to the contrary here. So it helps the mediator, okay? And then so once both parties reach a resolution, typically the EEOC will give you an agreement that you will have to sign to close the file. And then also the employer is going to give you an agreement as well. So there's going to be two separate agreements. The one that the employer gives you, be very, just make sure that you're really looking forward through it, because sometimes it can be very one-sided. I would say a lot of times it's one-sided. They'll put a non-disparagement clause in for them, but then, and they won't include you in that. I mean, you want to know, right? You want to know if another employer reaches out to them that they're going to give a neutral reference. They're just going to give the dates that you were employed in your title, and that's it. That's something you can talk about in mediation. Another thing that I think that should be talked about in mediation is a lot of times, right? Say, for instance, they'll say, okay, we're going to settle for $15,000. Well, what you want to make sure is that, okay, 5,000 of it, I want it to be for lost wages or back wages, because that's going to be taxed differently than the $10,000 for pain and suffering. The pain and suffering will not be taxed, right? It'll be taxed on your own. You got to deal with that with your, accountant or whatnot. So that is something that you talk about in mediation, because that can change a deal, okay? If they're saying, you know what, and a lot of times the employer will want to say that, no, we're just going to run it through payroll and we're just going to take all the taxes out. So that's something that you talk about to make sure that you're getting the best out of your mediation.
Excellent. We have so many questions coming in right
Yeah.
now, as you can imagine. And I'm going to try and group a bunch of these together. So first, there are a lot of questions with respect to what types of cases would truly qualify for EEOC? Is there so one of the things that I usually say to clients is when you go to the EEOC website, there is a phone number that you can call in order to, you won't be able to submit your claim over the phone, but you can have a conversation with somebody to understand whether or not your circumstances qualify or would be supported by the EEOC. Is there anything else that folks can do in order to determine whether or not their concerns are actually EEOC related or maybe another department?
Yes, I won't say that there's anyone that I think they may have liaisons that you can talk to. But they don't have many people that you kind of can live talk to. But what I do like about the EEOC is that they have guides for the employers that are really helpful if you read through them. They even have, so say for instance, for their ADA section, they'll have a whole regulation that you could read through. And it's pretty, I feel like it's pretty, like, it's not in legalese. It's
Okay.
information that you and I just can
Hmm.
pick up and just read. Remember, it has to be discrimination or retaliation based upon race, color, religion, sex, national origin, disability, age, pregnancy, or genetic information. That is what they have the ability to take in. So you have to remember that. And then once again, I will go on the EEOC section because it really kind of explains what elements you need, right?
Hmm.
So you may need to know, okay, what is determined by like a negative action towards me, right? So what if you were not only just termination is needed, maybe it has to deal with you didn't get a raise and everyone else got a raise, but you think because of your protected category status you didn't get a raise, or you're getting negative performance reviews and it's stopping you from being promoted, right?
Hmm.
So there can be different negative actions that you face that shows discrimination. And remember, retaliation, you have to make sure that you have the protected activity first, right? The complaint,
Hmm.
and then after you have the retaliatory behavior. So
Hmm.
just make sure you have those, and they look at that time frame, right? That's important, that timing, because we don't want to say, oh, okay, a year later then they started retaliating me, right? The closer kind of the better, or
Yeah.
you can prove that case.
Yeah. Um, that's really really helpful, and I do think that the documents out there are pretty easy to read and
Yes.
understand, and of course the Cagebird HR consultants are
Yes.
here to support anybody who is looking to understand whether or not they may or may not have a valid EEOC case. Another question that we've gotten a few times now is with respect to the difference between the EEOC and the Civil Rights Office, the state's Civil Rights Office. So somebody has stated that, their claim was with the EEOC, but then it got transferred to the state
Correct.
Civil Rights Office. What is the difference between the two? Is it possible to file a claim with the two?
Yeah, so you only are going to file with one. And when you file with the EEOC, it kind of asks you, did you file with someone else because they
Okay.
want to know? So those are those states where you're going to see they have dual filing. And so those are the ones that really you're going to see give you the 300-day option rather than the
Mhm.
180,
Yes.
right?
Yep.
So they are two different agencies. What you will see is the reason why your case is getting transferred to the EEOC is because a lot of these state agencies, they don't have the capacity. They have a lot of claims coming
Mhm.
in, and so they will transfer them to the EEOC for help. That's why you're seeing that. So you are dual filing. You can say that you're dual filing. Say for instance, Texas Workforce Commission. You're always going to get it on with the Texas Workforce Commission and the EEOC. So you're dual filing, yes. Um, as far as I tend personally to like the EEOC a little bit better
Mhm.
than the state agencies. However, there are some agencies, say for instance, like California.
Mhm.
I like California a little bit better. It just
We
depends
all
on
like
what
California.
state. Yeah, yeah. They are really, I think, worker friendly, but
Yeah.
then there's certain states that it's not so worker friendly. So you do have to weigh your options. Whereas the EEOC, you're going to get some consistency.
Mhm.
They also, I think that they have the best mediation program as well too, and so that's why I tend to file more on with the EEOC rather than the state agency because they do have a great mediation program.
That makes a lot of sense. So, if the EEOC transfers a case to a state's civil rights agency, it's likely due to capacity. The state would be able to manage this claim faster than they would.
It's normally reversed. So it's normally the state sending it over to the EEOC because they don't have the capacity.
Got it. Got it. So
Yeah.
we have somebody who said it was the opposite for them.
Oh, okay. I've never gotten that. I've always got it the opposite. So I've never gotten that.
Interesting. Interesting. Okay. And then when we talk about the rebuttal, you've discussed the rebuttal quite a
Yes.
bit. Do you have a recipe, for lack of a better word, in, for folks while they are developing a rebuttal? What should it look like?
Yeah, so let's talk about evidence, right? You're going to have your direct evidence, you're going to have your circumstantial evidence. Um, One thing that I always tell my clients is do not delay getting the information.
Mhm.
Keep in mind that these companies often use software to monitor your daily activities on their computers or
Yes.
equipment. So it's a good idea to collect all the relevant information as soon as you can, and sometimes before even filing the complaint.
Yes.
However, I want to say be careful in collecting this information because some states have business records rules. And
Mhm.
so if, there could be a situation where, oh, well, what are you doing with this data? So be very careful. Alternatively, I tell my clients if you're unable to get it, maybe even create a folder on the company system with all the information. I know it's kind of like letting your right hand know what your left hand is doing. However, that's the only way because it's going to allow an outside agency, the EEOC, to subpoena because they have the subpoena power. Then you can say, nope, all of that information is there, and they should have did a records hold or records litigation
That's right.
hold, and so they shouldn't be destroying that information. So that it will be there. So of course you want direct evidence. So that's written communication statements, your emails, and then also you want to look at for your circumstantial evidence, right? Patterns of behavior that you want to look for. And so I would Google what a legal brief looks like because
Mhm.
I literally would write it like a legal brief. I know some of y'all are like, well, I'm not an attorney. Google what it is. And
Yeah.
so what you're going to do is then you will just, as you're talking and making your arguments, because you want to put things in arguments, then you say, exhibit one, right? And then you're going to attach it all in your exhibits. And also, what could be helpful is that you bring up that position statement that they've written and you rebut everything that they've said,
Red line.
making your
Mhm.
argument. You just
Yep.
literally line by line
Yep.
go through it because I can guarantee you that it's probably not the most accurate representation of
Mhm.
what happened. Um, so I think that is the best in addressing. And also, I just want to mention really quick about your witnesses because maybe you might have some witnesses as well. Um, you can give these names to the EEOC. And I
Mm.
know sometimes individuals are very scared. Oh, I don't want to be a
Yeah.
witness. But give those names to the EEOC because here's the thing the EEOC can reach out to them. They have every right to reach out to employees, they have every right to talk to employees. And most of the rules is that if they say that, I need to speak to this employee, and if that employee is not a manager, the EEOC gets to talk to them privately. Now,
Mhm.
managers, sometimes they'll say, oh, well, we need our legal counsel in here. And so we're going to have our legal, so they will sometimes have the legal counsel in with the managers. So I definitely say please give the witnesses to the EEOC. And last thing is comparison information, comparison evidence. Make sure that you identify, it's crucial that you identify the correct comparator. So if, for example, if we're talking about an unequal pay case based on race, if the complainant is an administrative assistant, then you want to look for the same administrative assistant in the same department with the same manager. You don't want to go, okay, well, that teacher is making more than me,
Mhm.
even though they're in the same department, same manager. So you want to make sure that your comparators are the same as well, because sometimes we'll get that all over, and then
Yeah.
the employer will then have a good defense for that.
Yeah.
They're not doing the same thing as them. So
Absolutely. No, that makes a lot of sense. Another piece of this, and I think it's the biggest piece that sort of draws folks away from filing claims, either with the EEOC, the DOL, or even internally, is handling retaliation.
yes, that is huge.
Yeah, so if an
Um,
employee faces that after filing a complaint, what steps should they take to protect themselves? And how does the EEOC address retaliation claims?
Yeah, so like I said, the EEOC, about 60% of their claims are retaliation.
Hmm.
So it's not the initial claim, it is the retaliation. And so I just want to, I think, reiterate the retaliation part is that you're going to make sure the key factors in the EEOC, what they're going to investigate, they're going to look at causation. They're
Hmm.
going to look at whether there's a clear link between the protected activity, that's filing your complaint, talking to ER or HR, and the employer's retaliatory actions. And so it's really important that when you're looking at the actions, look at even the small actions. Look at if you begin to stop being, you're excluded from meetings, right? So you want to keep a clear record of dates and times that this retaliatory behavior is taking place.
Hmm.
The next thing that the EEOC is going to look at is the timing. They're going to look at the proximity between the employer's protected activity and the adverse action. So the retaliation that occurs soon after the complaint is often easier to prove. And then the third thing is the employer's reason, right? Whether that employer's justification for the adverse action was legitimate and pretext for retaliation. Now, I think these cases can get really emotional heavily on us because, they're going to be doing things, right? That after you have complained. So
Yeah.
just be careful to keep your communication or behaviors with them professional, because they're looking for every opportunity to say no. See, the reason why we did these actions is because they're a poor performer. See, they started poorly performing, or they're just acting egregious now, or
Hmm.
rude or disrespectful. And so just be careful, keep it professional, keep it classy, so that they can't use that as a defense. And
Yeah.
so, and remember about that evidence too, just the evidence that we went over, the direct, the circumstantial, and the comparative evidence, and make sure that you're documenting all of the actions that are occurring.
A great question that we have is around the NDA. So we know right now NDAs are, on the chopping block, but not
Yeah.
really. They're still around.
Mm-hmm. Mm-hmm.
Do NDAs prevent witnesses from participating in the EEOC process?
No, because remember, no one can take that right away for you to complain about illegal behavior, right? So you still can complain. Now, a lot of times they'll put in the agreements about joining a class action suit.
Hmm.
You may not have the opportunity to join a class action suit because you have already gotten your remedy. But once again, even with an NDA, you can, you've signed it, you can still go to the EEOC, and you can also file a complaint, and then you just might get, if you've gotten some already compensation, maybe like I said, monetary, you may not be able to get that monetary compensation because you've already had it. So
No, and I appreciate you restating that, because I know that when we speak with clients, we often do let them know that, accepting the severance dollars is essentially signing away your rights
it
to,
is.
monetary gains later on through processes like class action lawsuits or
Right.
EEOC processes. Essentially, what you're asking for is more process driven than
Mm-hmm.
anything, and a lot of times you're no longer working there, so it's not really to your benefit. um,
Right.
why go through such a grueling process only for them to say, oh yes, we'll add this to our employee handbook moving forward because we've already given you $5,000.
Well, I think something that is an advantage of is that if you go through the process and they are found by the EEOC to it was a cause finding, then the employer has to put up in maybe like a break room or somewhere, wherever they have had an EEOC claim and they
Oh,
did something, yes, they have to put that up for a certain amount of time. The EEOC will give them that notice. But remember, cause findings is very, very small.
yeah.
But I just went through one with it was a gender claim, and they have to put that up in their break room, that they were found a cause finding for discriminating against women. So that, to
Interesting.
me, that's an advantage.
It is. It is. And I guess I'm thinking more of, the impact to the client
Yeah, yeah,
themselves, right?
yeah,
For them, who's already gone through this experience and everything, there
yeah.
isn't a gain there.
I
However,
agree.
from your perspective, there is, which is a great point, there is this notice now that this is who you work for, right?
Yeah,
So
yeah.
that impact could be great for the employer.
Absolutely. And sometimes a lot of people are like, well, I don't want this impacting me, right, in my career, and I don't want someone Googling my name, right? Because if it's litigation, if
Hmm.
they Google your name, right, you're going to come up, right, in litigation. And I mean, sometimes you have to go there. But with the EEOC, you're not going to go there. Even if they find a cause finding, right, that is not something that is just public knowledge.
Yeah.
So it's kind of a good thing. And I guess I'm really, really passionate about this process because we have to stand up more.
Hmm.
I think that a lot of behaviors that goes on in the workplace, especially discriminatory behaviors, is because we don't stand up enough.
Hmm.
And so that's why I am more so like, okay, you're not there, but we still need to go through the process because we need to stand up for others that are still there. So that's the passion me. Sorry.
No, that's totally fair. That is totally fair. When it comes to witnesses, again, if they have previously gone through a EEOC complaint process and settled in mediation, would they be able to serve as a witness in another claim?
Absolutely. Yes, they still would be able to serve as a witness. I've had that happen multiple times. So yeah, they still could be a witness.
Okay. And I know in the beginning of the call, you had talked a little bit about the benefits of filing an EEOC claim on your own versus with the support of an attorney. And really, the greatest difference is the time frame in which you will get an appointment. Am I correct?
So with if you file with an attorney, the attorney actually will put the charge in for you. They will create the charge on the charge system, and it goes directly through the processing system. And so then within about 10 days or 2 weeks, it'll go straight to the employer. So you're not waiting for a call to speak with anyone, in appointment, to then go through the inquiry call and then they do the charge. That attorney will get that charge in for you within 2 weeks, that the employer will get it. And so I think that is really important because maybe some of you may be going through a performance improvement plan, right? And you think that performance improvement plan is really pretext or it's discrimination.
Mhm.
Or that that after that 30 days they're going to terminate you. You see all the red flags. Don't wait. Don't wait. And that's when I tell you, reach out to an attorney that can file you an EEOC claim, because sometimes some employers will put the brakes on it, right? They'll
Mhm.
say, "Oh, wait a minute. Maybe we shouldn't terminate. This is a risky termination.
Mhm.
Let's
Mhm.
think twice." And so that's why I say use the EEOC as a tool. I can't say that it's the best organization, right? They're gonna, fight for your rights and all of that. No, but I say use the EEOC as a tool, because some employers are like, oh yeah, we don't want our name with the EEOC. Um,
Yeah.
so
No, that potential to have to post that tag may be,
yes,
yeah,
yeah,
maybe
yeah.
enough for an employer to say, you know what,
Yeah,
we'll,
and you can go into the EEOC site and you can also see where they have demanded certain employers pay 50,000 here to the
yeah.
complainant. 50. You can read all of those decisions. So employers don't like that, that, especially big employers. We don't want to be associated with that type of prep.
That's really really good to know. Okay, so one of the other questions we have is surrounding the way in which an impact or the initial statement is created.
Okay. And
So,
so we talking about the mediation?
yes, yeah.
Okay. Okay.
So let's say, we can't afford to hire an attorney to support, because most attorneys, they want dollars on the table before they're
Yeah.
willing to go through a lot of these processes.
Yeah.
What resources can folks use in order to support these submissions on their own, the document writing on their own, the follow-up on their own?
Sure, sure. So, you know, like I said, start with reading the terms, right? What are the keywords? What are the buzzwords that are used in the acts, right? The ADA, right? And so you can also Google sample statements. You can Google those. But then also, I'm going to be real. We have Chat GPT. So be careful though, because things. I don't know if we trust ChatGPT to put your information in. So take out your name and the employer's
Yeah.
name and things like that. But write it all down. Take out some keywords from the acts. Write it down, and then put it in ChatGPT. Give it a prompt, like what, create an opening statement for mediation, right? And then put your information in there,
Mhm.
and it will help you create something that's really nice, I think, for, such a mediation. Position statements. I would really Google, what is a legal brief? What does a legal brief look like? You're also going to have the position statement that comes to you. Most of those position statements are written by their defense counsels. So you can mimic what that defense counsel
Yes.
did, right?
Mhm.
Um, and you can also run it through ChatGPT as well. So I think that that's key in getting prepared. But the number one thing is, just like I said, creating a comprehensive timeline.
Mhm.
Like, really write down, your dates of everything that happened, because that's how you're going to spell out your elements, your causation element, your
Mhm.
timing. And that's how you're going to really be able to maneuver through your complaint and help the investigator move through, or the mediation, present a clear case.
Awesome. Awesome. And then I will also add that obviously CageBird HR consultants are here to support in that process. A lot of us have either written these documents ourselves or have been through the process, as we all, at one point or another, worked in the HR department with big name organizations. So we would absolutely be able to support folks if you're looking for help in that regard. Our costs are a fraction of what an attorney would, charge as well. So definitely consider that. But then additionally, thank you so much, Monique, for sharing some of the other resources that folks could use in order to navigate this super complex process on
Sure,
their own. And
sure.
then I guess the final piece of this is, when it's all said and done, from start to finish, how long does it typically take for an EEOC settlement to be processed and funds to be distributed? Like, can an
Yeah.
employer try and, say, you know what, I want to appeal this decision?
So if we're talking about, if you're going the mediation route, it is going to take about 6 months, I think, to get to the
Mhm.
mediation. Once you've gotten to mediation, it's all about signing the documents, and most of the agreements that I see, they want it 21 business days, right? That they kind of would like to be, dispersed checks. Sometimes it's 14, but most of the time it's 21 days. Um, if we're talking about going through the investigation process, right? Um, you could be looking up to a year to 2 years. Now,
Mhm.
mind you, once you get to the investigation process, there could be. I've had times where the investigator said, I'm going to give y'all one more chance to get this right. I think you should you should mediate. And I've
Mhm.
been sent to mediate because the investigator, kind of recommended talk to them. or it could be a conciliation process, right? Where the EEOC thinks, you know what, this might be a cause finding. And so it can be kind of a forced kind of mediation. And then you're going back, but more so, this is when the EEOC themselves is more invested in the mediation, and they're going to really be the face of the mediation rather than it's you or your attorney, because they have possibly seen a cause finding. So that is going to be your time frame.
Thank you. Thank you. I think
Sure.
that, the process is pretty grueling. I
Yes.
think that one of the things is you got to have patience. You cannot be
Yes.
impatient in this process. It is not a quick resolution at all. So there's definitely that to keep in mind. And then
Yeah.
Monique, with our last few minutes, what words of advice, wisdom, empowerment do you have for our viewers this evening? We would just love to be able to walk away with some nuggets.
Yeah, I'll leave everyone with this. I think the EEOC is a very valuable resource. And I think we should learn how to utilize its services strategically.
Mhm.
If you have followed your company's internal protocols for reporting discrimination or retaliation and you haven't been given appropriate resolution, I think you should move to filing an EEOC claim. And if you see warning signs, once again, such as being placed on a PIP, due to protected category status, while your similarly situated colleagues are given better support than you, then I wouldn't wait to 30-day period to see what happens. File a claim. And file the claim. It really may help you seek relief, or by the time you transition to a new employer who really values you, right? You could be going through that. So, and lastly, I just want I think we must overcome the fear of filing EEOC claims. Um,
Yes.
these behaviors, once again, persist because we don't exercise our rights often enough. And we have to learn how to use these tools to become our best advocates for ourselves in the workplace. And so that's what I will leave everyone with.
Awesome. Awesome. All right. Thank you so much. I wish we could have gotten to every single question in here, but it is impossible. But what's also, I guess, deeply saddening is there are so many people who are considering this process, which, tells us that our work at Cagebird HR, your work at your law firm is so necessary. Of course, we're here to support folks in any way, shape, or form that you need.
Yes. Thank you, everyone.
Thank you.
Bye.